I often get questions on Twitter, and the approach of Halloween led to a number of questions related to the impact of death on privacy. A bunch of them were framed in terms of ghosts and zombies, but they are important legal issues. I realize that anyone who is searching for this sort of information is likely grieving and having a difficult time, so there will not be any costumes or creepy music, just the facts as best I can muster them. Hi, my name is David Fraser. I'm an internet, technology, and privacy lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should also know that I'm about to give you a pretty high-level overview of a pretty complicated and nuanced subject. Estates law and property law are within provincial jurisdiction, so the exact laws can vary from province to province. The laws also vary significantly from country to country, so what I'm talking about should be applicable to Canada only. And any opinions expressed are mine alone and should not be attributed to my firm or any of its clients. Can the family use privacy legislation to access the deceased's information? Most privacy laws, like the Federal Privacy Act, which regulates the federal government, or private sector laws like the Personal Information Protection and Electronic Documents Act, give an individual a very broad right of access to their own information. So can a family member or the administrator of an estate use those laws to get access to the same information on behalf of a deceased person? Well, it depends. The Federal Privacy Act, which governs federal government departments and agencies, specifically provides that the administrator of an estate can exercise the rights on behalf of a person who is deceased, but only for the purpose of such administration. How far the purpose of the administration of the estate extends is unclear. Our federal private sector privacy law, the Personal Information Protection and Electronic Documents Act, or PIPEDA, is much less helpful. It does not say that an estate trustee has any role or can act on behalf of a deceased person in any way. The only provisions in this statute that address any related topics is in Section 7, Sub 3, which permits an organization to disclose certain information without consent, but principally to permit a government agency, like the police, to identify the next of kin and to communicate with the next of kin. Subsection H says that the disclosures can be made without limitation 20 years after the death of the person. The proposed Consumer Privacy Protection Act, which is currently before Parliament, will address the issue in a way that's similar to the Privacy Act. It says, quote, "The rights and recourses provided under this Act may be exercised on behalf of a deceased individual by a person authorized by law to administer the estate or succession of that individual, but only for the purpose of that administration." It does say all the rights and recourses, which includes the access right, can be exercised by the executor, but again only for the purposes of administering the estate. Personal health information laws don't have that restriction. Here's the relevant provision from the Personal Health Information Protection Act of Ontario, also known as FIPA. The estate trustee or administrator is able to exercise the consent rights on behalf of the deceased, but without the restrictions found in the Privacy Act or the CPPA. FIPA also has a concept referred to as the lockbox. It essentially allows a patient to put certain information in a metaphorical lockbox so it cannot be disclosed to a certain person or used for a particular purpose. These instructions survive death. The custodian and the estate administrator have to take into account the wishes of the person from before they died. I think that's pretty important. If someone wanted to keep certain information from someone, that should be respected even after the individual has died. So what about accessing a deceased person's social and other accounts? One of the challenges that exists is that most social media and online services providers are headquartered outside of Canada. And that means that Canadian laws and the laws of the other jurisdiction come into play. A sad case study for this is the tragic situation that Ms. Maureen Henry of Ontario faced when her son disappeared in Toronto. His body was unclaimed for months and an autopsy was inconclusive. Understandably, she wanted to know more and tried to get the passwords for his accounts from Bell, Apple, Facebook, and Google. She went to the court in Ontario to get an order requiring these companies to provide her with access to those accounts. She got her order, and Bell was able to comply, as it is a Canadian company and exclusively subject to Canadian jurisdiction for this matter. Apple concluded it could also comply and provided her with access to his iPhone. Google and Facebook required her to seek a U.S. court order because they concluded that U.S. law would only allow them to provide full access to the accounts only with such an American order. Now, American lawyers with whom I work regularly would say that's the proper conclusion about the effect of U.S. law in this situation. Both Facebook and Google give users the ability, while they're still alive, to determine what happens to their account after they've died. Facebook allows you to designate a legacy contact who will have access to the account, but not automatically to Messenger messages. Google has an inactive accounts manager that allows you to designate a contact who can access and download your account contents. And importantly, you get to choose what they can access and download. Most estates lawyers I know strongly suggest that you write down or leave your account passwords with a trusted person who will be able to go into your account on your behalf to download or access your important account information. These days, it may be that all your family photos are stored in the cloud instead of in photo albums on your shelves. There's been some attempt at law reform here in Canada, including the proposed Uniform Access to Digital Assets by Fiduciaries Act, but this has not been passed into law by any province. And it will not address issues that arise because of non-Canadian laws. I really do think we could use more clarity in the law and to give effect to the wishes of the deceased. So what about privacy legal claims? Well, that's a bit tricky. As far as I can tell, none of this has been tested in the courts with respect to the modern privacy torts. Because privacy damages, other than straight financial loss, are very similar to general damages in litigation cases, we might be able to glean some insights from those cases. Provincial survival of action statutes provide that almost all causes of action or legal claims survive death, with the exception of a few legislated causes of action. A breach of privacy is not excluded under any provincial survival of action statute. However, the damages recovered may be restricted to actual pecuniary damages suffered by the plaintiff. Ontario law, for example, specifically says that libel and slander cases do not survive the death of the plaintiff. Sections 116 and 117 of the Federal Courts Rules provide a mechanism for transmittal of the action to another individual upon death. This requires that the claim to have been made while the individual was still alive. However, the federal court has also held that those provisions cannot be used in claims where the cause of action is inherently personal, such as charter equality claims. It's hard to imagine a situation in which the cause of action in privacy is not considered to be inherently personal and unique to the individual. In such a case, a claim that is only looking for general damages might be stayed following the plaintiff's death. I think we can conclude that the law is not completely settled in this area. Most of the statutes that deal with the survival of claims were passed long before the modern privacy torts were part of Canadian common law. Finally, I've been asked about photos of deceased persons. One example is funeral selfies, in which people take photos of themselves with the departed at an open casket funeral. That seems to be less of a legal issue than a matter of taste and decorum. I did, however, find a CBC article from 2017 which suggests that this is more common than I had expected, and is really part of a long tradition of taking photos at funerals. Now, as an aside, I was surprised that the CBC blurred the face of the selfie taker and not the body in the casket, and I didn't want to include that in my videos, so I've blocked it out. Another circumstance may be news reporting that includes a photo of a body or a crime scene where the body is draped in a blanket. Another circumstance may be news reporting that includes a photo of a body or a crime scene where the body is draped in a blanket. Again, that's not so much a legal issue. I'd consider it a matter of journalistic ethics and a determination of what is newsworthy. But I've also heard of individuals with their camera phones taking photos of crime scenes or accident scenes. I suppose a privacy claim could be made if it was highly offensive to a reasonable person, but so much of privacy claims hinge on the feelings of the person, and the deceased do not have feelings. If such a photo were taken for the purpose of causing harm to the family or loved ones, I suppose a claim for intentional infliction of emotional distress could be made. I've never heard of it happening, however. If you or a loved one are dealing with any of the issues I've described, I would strongly recommend seeking legal advice from a lawyer with experience in this area. It's all a bit tricky, and a lot of the legal issues are as of yet unresolved. I hope this has been interesting and useful. I try to put out a new video each week or so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.